Before I introduce everyone, I just wanted to mention a few housekeeping things. We're offering, as usual, auto-generated captions for this virtual event. Keep in mind that there are sometimes inaccuracies with the service, but we thought it was better to include it for accessibility purposes. In order to enable captions, click on the live transcript button at the bottom of your Zoom video screen. As usual, at the end, we have reserved some time for questions. To submit a question, you hover over the Zoom video window and click on the icon marked Q&A at the bottom. And then type your question into the white box that pops up and click return. All the questions will queue up on our end, and then we're going to get to as many as possible at the end. So without further ado, I just want to introduce, I want to welcome everyone here. Thank you for joining us. And I'm just going to introduce who we have as our panelists today. Joining us is Representative Edith Agello from House District 1. Hi, Edie. Representative Leonela Felix from House District 61. Hi. Our Executive Director, Stephen Brown, and Hannah Stern, our Policy Associate here at the ACLU. Hannah's going to start us off with an introduction of the 2022 legislative session. Hi, Hannah.
Hey, everyone. Thank you all so much for joining. And I just really like to thank Representative Felix and Representative Agello for joining us this evening. It's always really fun and interesting to hear the perspective of the legislators on the legislative session. So I'm very glad that they're with us this evening, and thank you all for joining us. Nicole, would you mind moving the slide forward? Thanks. So I think before we get in, we're going to go over some very specific bills this evening, but before I do that, I just want to give kind of a brief overview of the legislative session as a whole, and talk a little bit about kind of the breadth of the work that the ACLU of Rhode Island does. So we touch a lot of subjects as the ACLU. We have a very broad scope of the things that we comment on, of the things that we lobby on. And Steve and I are actually our lobbying team. So the two of us do all of the lobbying for the ACLU of Rhode Island. And there are a ton of bills introduced every year in the legislative session. But I always like to give a little bit of numerical evidence as to the amount of work that we do as the ACLU of Rhode Island as our lobbying team. So in the 2022 session, we actually tracked 986 bills. And of those 986 bills that we tracked, we actually commented on 339 bills. So as a whole, we lobbied on 339 bills. That is a lot of bills for two people to do. We're not going to talk about all of those tonight, obviously. We're going to talk about a very, very small percentage, which I know I'm very grateful for. Otherwise, we'd be here till 4 in the morning. But I just think that this gives kind of a very broad perspective on what the amount of work that we do as an organization is, and just also the sheer number of legislation and the sheer number of bills that actually moves through our state house every year. So we're going to get in on a few specific bills. We're going to kind of talk about these in sections. We're going to start with bills that cover equal protection. And I'm actually going to ask Representative Felix to start us off by talking about the driver's licenses for all bill, which was one really important victory of this session.
Absolutely, and it's my pleasure. I can't believe you guys actually testified and tracked so many bills, even just keeping in mind like my bills, trying to track those is a lot. So I really congratulate you guys for being able to do all that as a two-person team in terms of lobbying. So yeah, that's very impressive. So hi everyone, Representative Felix. I go by Leo and I use she, her, hers pronouns. I proudly represent District 61 in Pawtucket as a first-time legislator, and I actually just completed my first term as a legislator and will be running for re-election. So this bill right here is near and dear to my heart because for years as an advocate and for years before me, this bill has been advocated for by the Immigrant Coalition, has been advocated more by individuals. And what it does is basically it provides driver license privileges to those who are undocumented to allow them to be able to drive in our communities. So we know in particular with the COVID-19, the pandemic, how it really impacted all of our lives. And it really highlighted the importance of having meaningful access in terms of transportation, which we know in our state is not quite the best we're working on it. But we know that that is an important component in terms of being able to provide for your families, to be able to make it at school, to be able to make it to work. So, and finally, after I believe it's 14 years, Steve, if you can correct me if I'm wrong, around 14 years or so of advocating for this bill, finally, starting in 2023, the DMV will allow undocumented Rhode Islanders to be able to obtain driver's license. And there's a lot of requirements for it. Unfortunately, there's more limitations that I would have preferred to be in the bill, but I'm happy that it passed because it, folks need to prove their taxes or need to provide a slew of information. This will not serve as a federal ID. I know a lot of folks, particularly at the hearing or even on the House floor, were commenting how this are granting status to folks and how we shouldn't be intervening. And the reality is that what's not left for the Congress is left to the states to be able to enact. And this is one of them, whether or not to enact driver's licenses for all. So again, this is something that other states have done. Massachusetts actually passed it as well this year. I was really hoping that we were going to beat Mass, but we didn't, but we came in second. So I'm grateful for it. So thank you to the ACLU, because you guys have been at the forefront of this issue for many, many years in terms of ensuring its passage. So I don't know if there's questions or anything in particular you want me to go into, but I'm just grateful to be here.
No, that was perfect. Thank you so much, Rep. Felix. I think we're going to do questions at the very end. Oh, sorry, Rep. Jello?
I just would like to add that there is a driving insurance aspect to this bill. That's really a good idea. We all pay insurance, a certain amount of car insurance, for the possibility of being involved in an accident with an uninsured driver. If you can't have a license or a permit to drive, you can't get a driver's license, you can't get insurance. So this will make our roads safer because people who have to drive won't be driving without a license, and people who have to drive with a license will be able to have auto insurance. So it's a win for all of us.
Absolutely. And it's I failed to mention that. Thank you, Rep. Jello, for mentioning it, because this was a legislation that for years the insurance company was on board for. It was just a lack of will by the legislature to be able to move this bill, right? We knew previous speaker, Mariello, was vehemently opposed to this legislation and even campaigned on never allowing this to happen. So it was even more rewarding to be able to pass it this year, and as an advocate for the bill, to be able to actually vote in support of it. There's so many aspects to it that it's remarkable, and I'm it's so great that it actually passed.
Yeah, thank you so much, Reps, and thank you for that wonderful description, and thank you for your advocacy on this issue. I mean, I know this was like a very wonderful victory to have this session. And I'm so happy that this bill passed. And luckily we're about to actually talk about another bill that passed. So I'm going to pass it over to Steve to talk about another really important piece of legislation that passed this session that we were also involved in advocating on.
Thank you, Hannah. This is another victory. It's one that I'm very happy about. We worked with the Rhode Island College School of Social Work to get this bill passed. A real pet peeve of mine is the role that standardized testing plays in our society, particularly in getting professional licensing. And this is an example of that. In order to get a social work license, you had to pass this national standardized written exam. And the professors at the college were seeing that lots of students of color, even though they did fine to get their degree, clearly had all the capacity to be great social workers, found themselves stymied over and over because they had to pass this national standardized written exam. I've always believed that these types of standardized tests, that the only thing they do is measure how well you take standardized tests. They're really irrelevant in terms of showing whether you really can do the job. But more importantly, from a civil liberties standpoint, they have an adverse impact on certain students with disabilities in terms of how they can take tests, and particularly on students of color. I mean, the evidence is absolutely clear. When you look at almost all these exams, there's a disproportionate adverse impact on students of color. And that can be for a variety of reasons. You have students where English is not their native language, just all sorts of reasons. And they just serve as a completely arbitrary and unnecessary barrier to getting good people into important positions. And that's especially the case here with social workers. You want a profession that looks like, talks like the clients that they work with. And this test had been serving as a barrier. What this bill ended up doing, it was introduced, we worked on introducing it to simply ban requiring passing the test. What they agreed to do was have a 3-year moratorium. So for the next 3 years, students will not have to pass this test in order to get their license and to start working. And we're just very hopeful that 3 years from now, everybody will see the sky hasn't fallen, that there are lots of really great students who've entered the profession without having to pass this test. And I'm hopeful that we'll see it permanently banned 3 years from now. So again, another very good victory.
Yeah, thank you so much, Steve. I'm like, I can't stop smiling. I'm so glad we put these 2 victories at the beginning of the presentation, because I'm just like, it's exciting to relive the excitement of having these bills passed this year. So thank you, Steve. Unfortunately, we are going to go to another bill now that passed, but wasn't so great. So just to balance out the mood, I guess, balance out my smiling. Rep. Agello, I'm going to turn it over to you for a bill that concerns hotel ejection of guests.
Yeah, this, like many bills, probably most of the bills that introduced this bill is well-meaning in allowing hoteliers, people who manage hotels, to kick out guests who are behaving inappropriately in ways that are unsafe for staff or other people who are in the hotel. And so it was well-meaning legislation. But on page 2, there's a section, and I'll read it now. Use a person who uses verbally offensive language towards the hotel's employees, or guests for the purposes of either verbally, I'm sorry. For the purpose of this charge, verbally abusive language shall mean any language which would reasonably be found to be threatening, offensive, or demeaning. Now, threatening, offensive, and demeaning are, they're vague terms. Someone might say something to me that I might find threatening, and they might say the same thing to Leo, and she might just shrug her shoulders and walk away. Same thing about, offensive. All they're terms that are vague, and who's to say that Leo is more reasonable than I am, or vice versa. So the ACLU tried to alert members of the General Assembly and members of the Small Business Committee to this language and being okay with the rest of the bill. And the ACLU worked with a whole variety of other organizations, including Black Lives Matter, the ACLU, the NAACP, some Latinx organizations. I think that there were 20-some who signed on to the letter that the ACLU wrote objecting to the language that I just sort of stumbled through. And but nevertheless, the committee passed the bill and sent it to the House floor. So in a move of something or other, I rose on the floor when the bill was being discussed and asked if the bill could be separated, which is a technical term. I asked if we could vote on those specific lines separately. And if the House, if a majority of members of the House voted to exclude those lines, they would have come out of the bill. There wasn't much discussion. I read a list of all of the organizations that had signed on to the letter in opposition to that language. And the chair of the committee made a brief sort of defense. And then the House voted on the move to separate. And it was surprisingly close. My memory is that 30 or 31 members of the House voted to separate and eliminate that language, and maybe 33 voted against separating and keeping it in. So it stayed in. But I think that, I hope that in the future, committees will listen a little more carefully when issues like that are raised, questions like that are raised in committee about a bill. This is the last 2 years have been difficult and challenging because of the limits at various times on the number of people who could come and testify. Not this year, but last year we had testimony only virtually from the community in opposition or for bills. So anyhow, it was, the bill passed, it was passed the Senate too, was signed into law by the governor. I don't know if he did one of his signing ceremonies someplace, but it is now law, unfortunately. And I think it's a good example of something that's well-meaning, but just goes too far, and people aren't on their toes as Hannah and Steve are to catch language that really is going too far. My guess is it's going to be challenged at some point and found to go too far.
Absolutely. Oh, absolutely. And thank you so much, Repigello, and thank you for your efforts on the floor with that. We really appreciated it. And it was an important move to make, even if it did pass. So, but I think you're absolutely right. I think that that's a great example of kind of like why we need to be so vigilant and why the ACLU in particular actually does read so many bills, because I mean, Steve is famous for saying this, but the devil really is in the details. It's really about making sure that the language is as precise as it can be. So I think we're gonna transition over to bills that concerned privacy. I think this is obviously a very important topic right now for a multitude of reasons, and we actually have a whole variety of bills that kind of touch on this in a bunch of different ways. But I'm gonna ask Steve to talk first about one that has to do with medical records, please.
Sure. So this is actually a good example of both what you just mentioned and Representative Jello mentioned about a well-meaning bill, but where the devil is in the details. This was a bill that was put in on behalf of the state's behavioral health organization known as Buddha. And they put it in response to a lot of concerns that apparently were being raised by healthcare providers that they were having trouble transferring records to other healthcare providers because of the way the state's healthcare confidentiality law was drafted. And they were saying that if it was an electronic record or non-electronic record, if they had to fax things because they couldn't share it electronically the way the law was worded. So they needed this bill that vastly expanded circumstances when mental health records could be transferred to third parties without a patient's consent. In looking at the bill, we were very concerned about its breadth. We thought it ended up doing much more than simply addressing this very specific administrative bureaucratic problem that healthcare providers were running into. And we felt that it would really take away the privacy rights of patients to decide who should be able to see these very sensitive records. We made sure that it wasn't just me or Hannah, how we were reading it. We talked with a number of other organizations We talked with the Mental Health Advocate, the Mental Health Association, Disability Rights Rhode Island, and they all agreed with our concerns about how the bill was worded. So we testified against it. We raised these concerns. We offered language that would address what we thought would address the issues that it was designed to address. Unfortunately, it was one of these bills that gets voted on at the last minute. This was a bill that was introduced in March. It was voted on in committee a few days before the session ended in June. And when we tried to press for amendments to the bill, we were told it's too late. So unfortunately, the House ended up passing it. But on the good side, those on the senators shared some of the concerns that we and these other organizations had expressed. And so they did not end up passing the bill out of the Senate. It died in the Senate. I expect it will be back next year. What I'm hoping is that with more time that's available, our organization and the others who joined us in opposing the bill will be able to sit down with the agency and with supporters and try to come up with language that addresses the very narrow and specific issue they want to address without in fact compromising the very important privacy rights of people and their mental health records. So that was a victory, but I'm sure we'll be dealing with it again next year.
Great, thank you so much, Steve. So we're going to pivot now. We're going to talk about another piece of legislation, which I think actually really kind of demonstrates the importance of state statute in itself and is also really connected to one of our major ongoing campaigns in our organization. So just a little bit of background. Last August, the ACLU began to find out that the law enforcement departments of municipalities across the state were starting to implement these really widespread surveillance camera programs. These cameras were owned and operated by a private company, Flock Safety. And these cameras were being put in place without a public hearing or public oversight, or really without any limitations or safeguards in place. And they were able to do this because there was nothing in state statute that actually required this critical oversight. Of course, this was very concerning because having a statutory framework for any type of policing tool is really critical. But especially because this was putting in a vast privately owned technological system, which really had and has no legal and meaningful limitations. So this legislation was introduced to correct this, to ensure that if any police are considering the use of these really expansive surveillance systems, that they have to go through a public process to ensure that there's actually accountability.
Lost Hannah.
Hey, sorry guys, I think we lost Hannah for a second.
Mhm.
Are you there, Hannah? There she is.
To
Hey,
our-
Hannah.
Oh, yeah?
Hey, Hannah, we lost you for a sec. Can you just repeat
no.
the last like 10, maybe what, 15 seconds? What do you guys
Oh, yeah,
think?
absolutely. I'll just say that we just think that this can you hear me okay now?
Yeah.
Okay, thanks. Sorry, I was worried that was going to happen. But we're just really hoping to ensure through this bill that this technology itself is not being used as in an invasive and expansive a way as it has been. So very briefly, before I move on to the next bill, I do just want to note that our campaign to regulate these Flock Safety cameras is ongoing and very active. This is actually a really great example of one of our campaigns that is not limited strictly to our legislative work. We've been doing a lot of work on the municipal level on this issue as well. We have a ton more information on our website if you're interested in following along with our actions on this topic. So that was just my quick pitch for involvement beyond beyond the legislative session on this issue. But now we're actually going to move on to some legislation that had to do with students' rights. The first bill that I'm going to talk about also touches privacy in a really important way. I think it's another issue that's kind of growing in its importance, especially as more and more students are using technology, especially as technology is expanding. So the first bill that I'm going to talk about is one which has been a priority for our organization for a really long time in that respect, which would have provided students basic protections when they're using school loan devices and school loan technologies like laptops. And what this bill would have done is just guarantee that no school official or third party has access to the camera, microphone, or location of that device. I think that this is a protection which is really presumed to be in place for students. I think a lot of people are really surprised when they find out that there's actually no legal protections in this respect. There's really no state law that's protecting students or their families from these types of incredibly harmful intrusions of privacy. Unfortunately, these violations are also not hypothetical. There was a situation in Pennsylvania a few years ago where there was actually a school district that was found to have taken photos of students through the cameras on their school loan laptops while the students were in their bedrooms. And then they actually disciplined students based on incorrect assumptions of what they were doing in the privacy of their own home. So I think no one needs me to tell you how inappropriate this is. We've been fighting to put in place safeguards to legally and statutorily protect students from actions like this, which is especially important considering that most students in Rhode Island likely are required to do at least some schoolwork on a school-owned device. This bill did positively pass the House last year. It died in the Senate, but it's a huge priority for us. It's one that we'll continue to push for all of the reasons that I mentioned. So that's just one bill that kind of meets the intersection of students' rights and privacy. But one of the other really major areas that we worked on this session having to do with student rights, and another issue that we've been really consistently engaged with, is the question of police presence on campus through school resource officers, or SROs. The ACLU has held the position consistently that SROs are inappropriate personnel to be in the school environment for a number of reasons, but two of those major ones are because there are just so many other sorely needed professionals on school campuses, like teachers or counselors or social workers. And we just think that police really shouldn't be taking on these roles in the school environment when we do need these other specialized personnel. And we also hold this position because there are profound racial disparities and disparities for students with disabilities that we see in disciplinary enforcement protocol, like suspension rates. And we're really concerned that police presence can actually exacerbate these rates that we're already seeing. So we've also urged removal of SRO presence for this important reason as well. I bring this up as context because at the end of the session this year in late May and early June, a number of bills addressing SROs were introduced, presumably in response to the really tragic shooting in Uvalde in late May. And our organization is very understanding of the communal goal of safety. We all hope and look for safety for our students and our communities. But we did join a number of students' rights organizations in lobbying against bills that would have done things like mandatorily place 2 SROs in each schools, again, for the reasons that I just mentioned. But we did actually support one piece of SRO-focused legislation, which did positively pass, which collects data on SRO presence in Rhode Island schools. This is really important because we actually don't know how many SROs there are. We don't know where they're located. We don't know if they're in elementary schools. We don't know if they're in high schools. We don't know if they're in middle schools. So we do have really limited perspective on SRO interaction with students. So this data is going to be incredibly important and very helpful moving forward, just in giving an understanding of what our current SRO landscape looks like in Rhode Island, so that we can put forth really data-driven policy in the future on this issue. So that's going to sum up our students' rights sections. We're going to move to another topic, which I think is extremely relevant, to put it mildly, reproductive freedom. And I'm going to hand it over to Representative Agello to talk about one really important bill in this arena.
Thank you, Hannah. Reproductive freedom has and abortion rights. Let's just say the word, abortion rights, have become front and center since the Supreme Court decision. But all along, for years in Rhode Island, people who are employed by the state and people who are receiving Medicaid for their health insurance or eligible for Medicaid have not been able to use their health insurance provided through state employment or Medicaid to pay for an abortion should they need one. And that's a real access issue for people who need an abortion, and particularly people with limited income who don't have the extra $700 or more to pay for an abortion. And it, you know, as I think about it, I'm obviously past the time in my life when I would need an abortion. I did have one in my youth. It was not covered by insurance, and I would not have had it be covered by insurance, but I couldn't have because it was illegal at that time. But anyhow, I think the point I want to make is that people don't look at an insurance policy probably and think, is this going to cover an abortion? They may think that more now than they did 5 months ago. But in general, I think, nor do they maybe look at an insurance policy to see whether it will cover certain sorts of cancer. They just assume that an insurance policy that is offered to them by their employer is going to do a good job of protecting them in the case of needed care. So the Equal Access to Abortion Coverage Act, the EACA, would add Medicaid coverage for abortion and abortion coverage for state employees. And this, the impetus really came from state employees at URI, as far as I understand, in the first introduction of the bill. But anyhow, it was introduced this year, had a very good hearing with lots of support in the House. I was there from the Finance Committee hearing for a good half of the hearing, and really positive, evocative coverage. I think that we have a majority of members of the House in support of it. So hopefully the members who are in support will be reelected in November, September, and November. And that those new ones that we get will also be in support of the EACA, and we'll get it passed and into law, hopefully in January, February, or March, when we first get back to work at the State House. So that's the EACA.
Thank you so much. Oh, sorry. I didn't mean to interrupt.
It's kind of when we passed in 2019, the Reproductive Privacy Act, we codified all of Rhode Islanders' rights according to Roe v. Wade. We eliminated a lot of bad laws that were unenforceable, but were still on the books, and really made Roe v. Wade the law of Rhode Island, so that Rhode Island isn't really harmed by the passage of the Supreme Court decision, other than that we live now in an environment where there is not that assurance. So,
yeah, thank you so much. Oh, sorry.
We have a majority of Supreme Court justices that don't see a person's right to privacy about their own body as something that the Constitution recognizes. That's where we are.
Yeah. Well, thank you so much for that description, and thank you for all of your years of championing abortion rights in Rhode Island. I know we all are so appreciative of your continued work on this issue. So thank you so much. We are going to move on to another topic of bills. We're going to move on to bills that concern criminal justice, and another major bill passage for this session was the legalization of recreational marijuana. So Representative Felix, if you don't mind taking over for me to talk about that. Thank you.
Absolutely, and thank you. So yeah, we made history in terms of Rhode Island finally legalizing recreational marijuana in the state. And not only did we, after many, many years of advocacy, maybe I should back up. So first of all, the law decriminalizes the sale and possession of up to 1 ounce of cannabis for those who are 21 and over. And then no more than 10 ounces if you're keeping it at the residence. So now it would be legal for anyone to be able to have up to 1 ounce and consume it recreationally. And in starting in early January, they're going to begin the sales or processes to be able to get the sale. But apart from the being able to pass the legislation to make it recreational, what was really astonishing was being able to advocate for the inclusion of a state-initiated automatic expungement process. And for those who are not familiar, I'm just going to back up in terms of terminology. For those who are not really familiar with the two different processes. So in terms of expungement, there's one, the petition-based process, which is what most of us know, which is you walk into court, you file a motion, if you're eligible for an expungement, and then you go before a judge, you go through a hearing, and then they determine whether or not it's eligible to be expunged, yada, yada, yada. You have to bring your paperwork to the court, to the police station, to all these places to be able to get your records expunged. Very time consuming, very ineffective. Then there's another process, which is the state initiated expungement. And that is where the state bears the burden of being able to expunge those records. So they are responsible for identifying those records that are eligible for expungement and then initiating the expungement, basically removing the person from the process. The reason why this was extremely important to me was because we know data shows that those petition-based processes are extremely, extremely ineffective. And about I forgot the data exactly. I have it somewhere, but the rate of those who have been able to access expungement, I believe, is about 6% in those who have petition-based. Whereas for states that have state-initiated, is actually 80% or more that have been able to access expungement. Not only that, but it's also more time-consuming. It's more costly to the individual and the state to do petition-based. So for all of those reasons, and many, many more, equity, justice, everything in between, it was important for me that this bill included the automatic expungement piece or the state-initiated expungement piece. I use both just because folks know the terminology either way, but just know that I mean state-initiated. So we were able to advocate, work together with national partners, local partners like Yes We Cannabis, Reclaim RI, and many others, to be able to advocate for the inclusion of that piece. The ACLU was instrumental in making sure that it happened. And yeah, it was extremely exciting when it finally ended up passing, and to be able to have such a big social equity piece to this legislation. There's many other provisions apart from the automatic expungement. For example, like the sales will begin October 1st. Adult sales will begin October 1st to December 1st. It allows for 33 licenses for cannabis retailers statewide. We have the co-ops that is aimed to help folks who are unable to access the field, because we know it's extremely costly, to be able to go into partnerships and be able to get into the field and be able to get into the business of selling marijuana. Because again, those who have been directly impacted, for them to not be able to get into the business, to me, it's ludicrous. We're gonna now get revenue while folks have been incarcerated and harmed by the war on drugs, and particularly marijuana. I can go on and on. We established zones in terms of where certain licenses can go, certain places where they can go, distribution, remove barriers in terms of accessing the field. And also one of the big pieces that at the end of the session that we were working on with Steve and the ACLU member team was that we were imposing restrictions on medical marijuana users, patients, it was a lot more stringent than recreational. So we were trying to make sure that the bill was cleaned up so that those who are medical patients didn't have to jump through hoops that us who are going to be using recreational didn't. So making sure that things are just equitable for all users, and so on. So yeah, another amazing win for Rhode Island. I get very excited.
No, I am too. I mean, again, it's like the same thing where as we're talking about the victories, I'm like, yeah. So thank you so much, Rep. Felix, for your very, very wonderful description of what is a very, very long and complex piece of legislation. I am sure that we will all be very glad not to have to read 125 plus pages of legislation on marijuana policy again next year. So this is really a victory for multiple reasons. But the next piece of criminal justice legislation we're going to talk about is, I think it's really fun to talk about actually, because I think it also exemplifies not only the goal of our lobbying and the importance of community feedback, but I think it also ties back to what we've been talking about kind of this entire webinar, which is about the importance of really just looking at the language of a bill. Again, how the intentions of a bill can be lost in imprecise language, and if it's passed as introduced or drafted, could have some really harmful effects. So the original language of this bill would have required background check procedures on any person who instructs or teaches an individual or individuals under the age of 18, even if those services were conducted privately. And the ACLU generally has concerns about how broad criminal record check requirements can impact justice-involved individuals. But this bill would have also put in place this requirement without any formal enforcement or appeal process, and would have potentially imposed a very unnecessary burden on parents who just may not know that they would have to legally ask for a background check for their child's private piano teacher. But then we also pointed out that the language of this bill, as written, and as introduced, could have applied to students who were engaged in peer-to-peer tutoring. So potentially you could have put any high school student who does tutoring on their lunch for volunteer hours in the position of needing to get a background check just to volunteer for their peers. So we did ultimately, because of our lobbying and these concerns, secure an amendment to this bill, which narrowed the scope of the bill and which has allowed us to be neutral on the legislation, which is really great, but I think also just, again, a really important example of what lobbying work does and can achieve outside of the kinds of focus bills that we've talked about this evening otherwise. And so I'm actually going to go back to one of those important focus bills. I'll ask Representative Felix to talk about this next really important piece of legislation.
Thank you, Hannah. So this legislation, what it does is that it prohibits juveniles to be questioned by police without the presence of their parents or without the presence of an attorney. And this is extremely important. We've all seen, and if you hopefully, you've seen it on TV or some of us personal experience in terms of being questioned by the police in general, even for an adult, is extremely scary. It's extremely intimidating. You watch these TV shows and you know that you're going to go and you're going to plead the fifth and you're going to do all these things. And then you get to the room and you're like, I don't even know how to count to 5 at this particular moment. Like, I don't even know what the fifth is. Right to remain silent. Always know that. And we know in particular when it comes to youth that their brains are not developed as adults. I think it's up to the 26 years old when a child's brain or a youth's brain is actually developed. Youth, as we all know, we've all been through it, are more impulsive, get into more trouble, and don't really go through the consequences of their actions, right? So to be able to allow an adult, a police officer, the symbol of authority over a youth, without the presence of an attorney or without the presence of a parent, to then incriminate themselves and potentially get themselves into some legal liabilities is extremely, extremely just bad policy all around. We know that about 90% of youth who are giving Miranda rights, and that's the right to remain silent, the right to an attorney, for those who are not familiar, actually waive the Miranda rights. So it was extremely important for us to really rethink in terms of what are we doing to protect juveniles when it comes to interrogations, and to make sure that their presence of an attorney is there, or their parent who can more comfortably say, no, we're not going to talk until an attorney gets here, or we're not going to talk at all, or what ifs, other opportunities. But without the presence of a parental figure or without the presence of an attorney, again, we know how much trouble a youth can get into by speaking to the police. And hate to say it, but they don't always have your best interest at heart. They never have your best interest at heart, because the reality is that they're there to solve a crime and to, catch someone for it. So unfortunately, a lot of the youth get into a lot of trouble. So this legislation was extremely important to make sure that we pass, to be able to protect juveniles who may fall into the system, who may need assistance, and who may not know what their rights are under the Constitution.
Great. Thank you so much, Rep. Felix. So we're going to transition away from criminal justice. We're going to talk about, I think, what one of the kind of opportunities of this session could have been. So unfortunately, there were a number of police reform pieces of police reform legislation which did die in committee. I'm going to ask Steve to just briefly talk about a few of those which we will continue to be advocating for in the future.
Thanks, Hannah. So far you have heard about a number of successes, bills that passed that really are promoting important civil liberties. I think one of the biggest disappointments of the session was what didn't pass, and that was anything meaningful related to police reform. You know, it's been 3 years since the legislature has been back after the George Floyd protests that occurred not just in Rhode Island, but across the country. There are many states that have responded to those protests by passing various pieces of police reform legislation. Unfortunately, Rhode Island is not one of those states. And this year again, the General Assembly passed up the opportunity to address some of these issues. There are just 3 that I'm just going to very quickly mention and say that I hope we will see some movement finally in 2023, because this is an area that really does need to be addressed, and we're hopeful that the legislature will finally do something. One of the bills that did not pass, that we've been working on with a number of other civil rights groups, is reenacting a law that expired 2 years ago, requiring every police department in the state. No, you can go back, Nicole, to the previous one. It would have required every police department in the state to collect data on traffic stops and traffic searches in order to look for racial disparities. The law was first enacted back about 20 years ago. And when the law has been in effect, there have been very comprehensive analyses done of the data. And unfortunately, they always show the same thing. They show that police departments are much more likely to stop drivers of color than whites. They are much more likely to search drivers of color than of whites. And yet they are much more likely to find contraband on the white people they search. The idea behind collecting this information is so that police departments have it and can act on it. But because it expired 2 years ago, we've been working to try to get it reenacted. Unfortunately, due to what I think were unreasonable demands by police chiefs, the bill did not pass this year. We will be back next year to try to get it passed, because we think collecting this information is absolutely essential if we're serious about doing something about this very deep problem of racial profiling when it comes to traffic stops and searches. A second bill that didn't pass, that was sponsored by Representative Agello, had to do with access to police records. For many years, police departments routinely handed over to the public final reports of internal investigations of police misconduct. These were turned over without any identifying information. They were able to redact the names of the officers, but at least you were able to keep track of how many investigations were conducted, what were they conducted on, what were the results of those investigations. Unfortunately, 2 years ago, as a result of a Superior Court decision in a lawsuit that we had filed against the Pawtucket Police Department, a judge ruled that these records were no longer automatically public, that police departments had the right to examine them on an individual basis and determine whether they should be released using a variety of different criteria. We strongly oppose that decision. The court case is pending. But what we did was we put in legislation that would clarify and make it absolutely certain that once an investigation was done, the public would have a right to see what happened. Unfortunately, again, because of opposition from police, this bill did not pass. It is something we'll be back again next year, hopefully with Representative Agello at the helm, helping us. And in the meantime, the court case will continue. But one way or another, we hope that the public ends up with the access that we thought they had for many years in seeing how these investigations turned out. And then the third and final one that I'll mention for now is one that you may be familiar with, because it got a lot of attention a couple years ago, and that's Rhode Island's Law Enforcement Officer Bill of Rights. This is an incredible statute. It was passed 45 or so years ago, and it provides incredible protections to police officers before they can be disciplined or terminated. And when I say incredible protections, I think the example that I always give is that before questioning a police officer about misconduct that they're alleged to have engaged in, police departments provide those law enforcement officers more rights, more protections than a criminal defendant who faces life in prison has when they're interrogated by police. It's truly outrageous. There's been, the police chiefs have said that they would like to see reform. Many members of the legislature have talked about wanting to see reform, but for whatever reasons, it's been hung up. People have not been able to come to a consensus on how to amend the law. There's an effort by some to repeal it entirely, which we would support, but not even getting amendments has been very frustrating. So this is something that people concerned about police misconduct we'll be back next year working on this, and we're hoping that finally Rhode Island will join so many other states in passing police reform legislation, because it's long overdue.
Thank you so much, Steve.
Can I ask a quick question? How many states have as restrictive a policy as our LEOBOR?
There are only a handful of states that actually have a LEOBOR. I think it's less than 10, I think. Rhode Island is considered to be the most protective of all the statutes out there. So we have work to do.
Yeah, that was a very good question to provide that context. So thank you so much, Rep. Agello, and thank you, Steve. Luckily, so there were definitely a lot of opportunities this session, including the ones that Steve just went over, but we actually also had to close out kind of our summaries on some of the specific pieces of pieces of legislation before we move on to questions. We did have some victories in the arena of voting rights, which were very exciting. So I'm going to ask Steve to talk about the first one, please.
Sure. So the first issue, first piece of legislation has to do with prison gerrymandering. Now, I'm sure everybody knows what gerrymandering is, but what is prison gerrymandering? This is a concept that somebody brought to everybody's attention about a decade ago that nobody had really been thinking about at the time. But when the legislature at the state level or a city or town at the municipal level starts redrawing its district lines every 10 years as a result of reapportionment, the question becomes, what do you do with individuals who are incarcerated? Where and how do you count them? And it was pointed out that the practice had long been wherever the prison was, all the individuals in that prison were counted as residing there and therefore residing in that particular district. So here in Rhode Island, you have 2,000 plus individuals at the ACI, all of whom were counted as living there in Cranston in this particular area. Even though under state law, people at the ACI who have the right to vote have to vote from where they came from their home district. That's the ballot they get, even if they are incarcerated. But under the redistricting that had happened for so long, they were counted as living in Cranston. And what that means is you had a district in Cranston that had 2,000 people that the person representing them really didn't represent. And so inflated the power of whatever legislator or city council person had that district. And at the same time, it deflated the influence of the districts where these individuals came from, often from urban areas where they were not counted, even though that's where they voted from. So for a number of years, we had been pushing to get a law passed that would say when you're doing redistricting, you count people at the ACI from where their home district is, not from where they are in Cranston at the ACI. And we've been unsuccessful for many years, but this year there was the once at every 10 years redistricting that took place, and we got a partial victory. The legislature agreed to a sort of compromise. They agreed to count any individual who was serving a sentence of 2 years or less, or was there awaiting trial. They agreed to count them from their home district. That amounted to about 40% of the ACI population. We thought that was a really important step forward. And now we're hopeful that in the coming years, we'll be able to permanently take care of it for the next census and have 100% of the individuals at the ACI counted from their home district, so that we eliminate this problem of prison gerrymandering. But again, we were very pleased to see this very important first step.
Can I just comment real quick? It's been such a crazy 2 years. I had actually forgotten about the prison gerrymandering and this victory that we got. For some reason, with everything that has happened, I am so glad you reminded me of this, because this is extremely important.
Yeah, I mean, listen, there's so many bills. As we put the numbers up at the beginning, there's so many bills, there's so many things to keep track of. But thank you so much, Steve. We're gonna talk about our final bill now, which was another victory, another really important victory, extremely relevant as we approach the primary on September 13th. Don't forget, the voter registration deadline is August 14th, this Sunday, just in case anyone needs that. And I'm gonna ask Representative Agello to close us out with this portion of the wrap up and give us the summary of the Let RI Vote Act.
The Let Rhode Island Vote Act was the work of a really impressive group of good government advocacy organizations, including the ACLU and the League of Women Voters and Common Cause. And oddly enough, I think that the COVID pandemic helped. The sort of emergency for the pandemic, easing of the restrictions on mail ballot voting, getting rid of the requirement of witnesses or notarizing for people doing mail ballot during the pandemic, and finding that the sky didn't fall. There weren't instances of people voting for other people or other kinds of voting fraud. We had a very good election, and we had actually a very high turnout election despite the pandemic. And that was in part because of the easing of the mail ballot procedure by getting rid of the witness or notary requirement and easing the application. There's no longer any requirement that you have a excuse or a reason why you can't vote in person. You can just say, I want to vote by mail. The pandemic also participated or helped with getting early voting to start happening around the state. And that also, I think, worked to increase turnout, increase the vote. So those are both things, important parts of the Let Rhode Island Vote Act. There also is, I think, for those of us who want to see results of elections. I remember on election night in 2020, when they were first talking about the results coming out of the vote count, Trump was leading in the state. And one of my colleagues from work called me and said, how can that happen? And I said, I think it's happened because so many people voted by mail or early voting, and I think most of them were Democrats. This is going to change when we get the results from the early voting and from the mail ballots. Well, now the Board of Elections, because another part of Let Rhode Island Vote Act is that the Board of Elections can start counting the mail ballots and the early voting ballots before election night, before the polls close, and even the days before. So we'll have our results more timely. There is another requirement in the bill that the Secretary of State's office set up a hotline for people to call, the hotline to be staffed with people speaking a number of different languages, not just English, for people to get information about how to register to vote, where to register to vote, and also where they vote and when they vote. All that information on a hotline through the Secretary of State's office, and as I said, with staffed with a number of different languages. So there are a number of different other parts, but those are, I think, some of the highlights.
Yeah. Thank you so much, Rep. Agello. And I have personally called that hotline, and I can confirm that it was very helpful. So you can take my firsthand experience on that. So that concludes kind of our overall picture of some of the bills that we talked about, some of the bills we lobbied on. I just want to thank Representative Agello and Representative Felix so much for your perspective, for your wonderful summaries of all of these really important bills, for your advocacy on all of these bills, for your continued work on civil liberties. We're really appreciative, and thank you for joining us. But before we move to questions, I just want to really quickly say that we have, if you're really interested in the work we're doing and you're thinking that it's something you might want to participate in, we have so many resources on our website which cover Advocacy 101 tools, how to testify, how to write to your legislator, even information on how bills become laws, because I think it can be a very confusing process. I don't think any of us would deny that. So we have a lot of information on our website about that. And then we also have, obviously, this is a very small percentage of the bills that we lobbied on, that we talked about tonight. On our website, we also have a lot of information about a bunch of the other bills that we talked about, including our testimony, our position, the bill language. So all of those resources are on the website. I can confirm that there's a ton of them because I personally put them up myself. So we really encourage you to visit our website if you have any other questions about our legislative work or questions about what our positions on any other bills might be. Oh, Representative Felix, yes.
So I wanted to plug in terms of additional documents that may be helpful for anyone who's in listening to this. So the Rhode Island Legislature also publishes all of the documents, support or opposition documents for any of the bills. So you can always see it there. So if you have any questions in terms, I know there's a question that we're gonna go to, but if you have any question in terms of like who opposed these bills or who supported it and wanting to talk to folks, if you go under the main page under documents, you'll find every single piece of support or opposition letter that was submitted for bills. So that's another helpful resource.
Yeah, thank you. Thank you so much for bringing that up, because I do think that that's really a very invaluable resource. I use it all the time myself. So again, another thing that I can personally testify to the usefulness of. So we are going to move to questions. I'm going to ask Nicole to come back and help us with that, if that's all right.
I'm here. Hi, everybody. So it's time for questions. I just want to thank Hannah, by the way, for talking about the resources. So as a reminder, I just wanted to let everyone know to submit a question, you mouse over the Zoom window and click on the icon marked Q&A. I know we have some already, so we're just going to dive right in. One second. All right. So as far as I understand, all the panelists can see the open questions. There's also a couple more in the chat. Shall I just go down the list? There's actually a lot of really interesting questions. The first one we have is, so the Hotel Ejection of Guests Act can be used / abused to disproportionately discriminate against people of color, ? And I'm just going to let whoever wants to jump right in, I think.
I'm happy to. The answer is yes, exclamation mark. We all know that something as vague as, you made an offensive or demeaning comment is going to be used by hotel managers in a discriminatory way. They are not going to throw out the the guest who comes every year and rents the most expensive suite in the hotel when they make an offensive comment to one of the maids. It will be abused and misused against people that they may not want there. And as Representative Jello said, I think this is ultimately going to end up in court. We think there are serious constitutional problems with the bill, but there's no question in my mind that giving hotels that sort of power will be used discriminatorily.
Thanks, Steve. Next question.
Can I,
Sorry,
Nicole, do you mind if I also make a quick comment about that?
Absolutely.
The other perspective is also that, and Rep. Ajello touched upon this on her testimony, is that what has meaning for one person or conversation like is very different for another. So for example, if with me and my friends, I don't know, we use the B word and communicate with each other or whatever, and we go ahead and we say, oh, this B word to the maid as we're walking away, that can be used to kick us out, right? So I'm not saying it's okay to do it. I'm just saying that it can be used in this way, as Steve has pointed out, to really just expansive, because it is really a subjective test of what is offensive. And again, what's offensive to one person may not be offensive to another. So also keep that in mind.
Oh, thank you so much. Actually, this next question, you can probably speak to that as well. Leo, is there any data on how many people are serving time for possession/sales of cannabis and how many are seeking expungement? I don't know if you know the answer, but.
So it's really complicated. And I don't know if Steve, if you've seen all the data, but we have the problem with the way that our laws are is that we've originally classified anything that was cannabis at some point as cannabis. Others are as controlled substances. So it's very difficult to know exactly how many people actually have past criminal convictions for cannabis, or even the amounts. And then how many, I haven't seen data in terms of how many are actually incarcerated. And I don't know, Steve, if you have anything regarding that.
I don't have the data, but we
Yeah, so
there are lots of people who are eligible for automatic expungement, that's for sure.
yeah, so we're looking right now. So I'm working together with some national partners to gather data. So the court had sent us information in terms of people who would be eligible. And just in the first scan, there were over 20,000 records that were eligible. And that was just from the initial scan. The bill hadn't even passed. It was just trying to figure out numbers. So we're still in the midst of collecting information or getting information from the courts. One of my biggest pet peeves with the legislation was that in the drafting, we had included reporting requirements. We had included reporting out requirements for the courts and the attorney general, which did not pass. But I'm hoping that for the next couple of years, next year, hopefully we can kind of amend the bill to include these reporting requirements for us to really see the big picture of how many people are getting records expunged, how many people were eligible but were denied, and so on and so forth. But I'm hoping to follow up in regards to that question.
Can I just add, my understanding, the logic behind expunging is that there are people with records, criminal records for crimes that with the passage of the Marijuana Act or the Cannabis Act, not a crime anymore. Possession of up to an ounce or 10 ounces in one's home. That's not a crime anymore, but there are people with records for exactly that. And it really doesn't make sense for them, for that to remain a criminal record, something that employers and others might hold against them.
Yeah, and I see the question that Anusha raised in terms of what is the offenses that are automatic expunsion is exactly that. It's the possession of 1 ounce of marijuana. And for those, there's a presumption that because again, if it's named as controlled substances or as cannabis without the amount, there's a presumption that it is the amount that is under 1 ounce or 1 ounce or less, and it will be automatically expunged as well.
Thank you so much for those answers. I think we're going to just do one more question just because we're supposed to close at 7:15. And I want to make sure that people have time to get on with their evenings. You can always email us at info@riaclu.org if there's another question that you would like us to answer, or if there's something that we didn't get to that you're really looking for the answer on. We're always happy to answer those. I love to answer emails, so chances are it'll come from me. So we're just going to do one more very quickly. What were the arguments made in opposition of the juvenile interrogation bill? That's an excellent question. I can't think of a single opposing piece of testimony that was given for it. And I think Representative Felix is shaking her head. I think,
No.
I think you're agreeing with me? Yeah.
Yeah, I searched the documents, as I mentioned, while we were talking about it. There wasn't a single opposition for it. I don't know if there was maybe secret conversations or private conversations, but publicly there were not. I think it would be a really good bad position for someone to publicly oppose that, but that's just.
I think I tend to agree with you on that. But yeah, so I think that's also a really good example of a very common sense piece of legislation that a very common sense piece of criminal justice legislation that we will continue to be pushing for. Thank you again, everyone, for your questions. Please email us if you're still looking for the answers to those. I'm really sorry we didn't have time to get to all of those, but I'm gonna send it to Steve really quick for some very quick closing remarks. I just wanna thank again, Representative Agello and Representative Felix for joining us, and thank you again for everyone for joining us this evening to talk about the legislative session in August. I really appreciate it. So Steve?
I wanna say thank you to the ACLU for being there consistently, for reading all these bills, and for keeping us informed, for working harder than I can conceive, and many of my colleagues can conceive, at reading the bills carefully, thoughtfully, and pointing things out to us in ways that nobody else does. So you are an invaluable asset to the state of Rhode Island. Thank you.
Thank you, Representative Agello, and thank you, Representative Felix, for all the work you're doing at the State House. We can come up with all sorts of great bill ideas, but it takes you on the ground to actually get them passed. And so we really appreciate all you've done to help with some of the bills we've talked about tonight. I just want to say a few words before Nicole formally closes us out. I too want to thank everybody who stuck around to listen to this. I hope you found it informative, and I hope that you will help participate with us. I encourage you to go to our website. You can sign up to receive email alerts during the legislative session. If you're interested, just go to our homepage. Also on the homepage, you can join the ACLU if you aren't a member and donate to us. We really need the donations. This work does require money. And I hope that what you've heard tonight demonstrates that your money would be put to good use. It is being put to good use, and we hope you'll help us in that regard as well. But thanks again for taking the time to listen and be informed, and I'll send it off to Nicole.
Hey, everybody. Thanks, Steve. Just as a helpful little note, I posted the URL for the Rhode Island ACLU in the chat, and I'm pretty sure everyone can see that. So thank you to our panelists as well, Leo and Edie, and to everyone who joined. Just as a final note, if we didn't get to your question, look for a follow-up email from me, and don't hesitate to reply with your question. I'm happy to do my best to get it answered. And then finally, you'll also get an email. In that email that I send is going to be a link to a survey, because we really want to hear your feedback on what you thought of this wrap up. So have a great evening, everyone, and thank you again for joining us. Bye-bye.